I want to be able to settle in and settle down and have exactly what I want. I want 5 bedrooms. I want to be close to the rest of the family. I want my kids enrolled in the same school. There's certain things that I want and certain things that I deserve to have. I like the routine that I'm developing with my kids. I really like it. You know, we've gotten more where we say prayers at night.
You and Mary, you guys feel like I'm giving you more by having you this far apart from each other.
Yes.
Really?
Hi besties, buckle up, because today we're unpacking one of the most surprising legal dramas to hit the sister-wives world in years. Imagine this, you're a college student, quietly carving out a life away from reality TV cameras, when a single moment on a busy Salt Lake City interstate changes everything. A sudden brake light, a split second of distraction, and a chain reaction of crashing metal. Fast forward to now, and that brief accident has turned into a full-scale lawsuit demanding a staggering $225,000. The person at the center of it all? Ysabel Brown, daughter of Kody and Christine Brown, the same Brown family whose plural marriage journey we've followed on TLC for over a decade. This isn't just a routine fender-bender claim. It's a legal chess match mixing Utah traffic laws, comparative fault rules, and the complicated reality of public figures trying to live private lives. Over the next several segments, we'll break down every angle. The accident itself. The lawsuit's key allegations. How Utah's insurance and negligence laws work. And what this case could mean for Ysabel's future, and maybe even for the entire Brown family dynamic. So pour a cup of coffee, settle in, and let's start from the very beginning, the day of the crash. Let's rewind to 2023. Salt Lake City's I-15 corridor is notorious for heavy traffic and sudden slowdowns. Anyone who's driven it knows how quickly a normal commute can become a nightmare. It was here, on a stretch already marked by frequent multi-car pileups, that Ysabel Brown found herself in the wrong place at the wrong time. According to the police report and the subsequent court filings, traffic that afternoon was unpredictable, stop-and-go with brief bursts of highway speed. Ysabel, driving her compact sedan, was following another vehicle when the chain reaction began. The driver ahead braked sharply. Ysabel hit the brakes too, but in those critical seconds her car made contact with the rear bumper of the vehicle in front. The impact, though not at freeway top speed, was forceful enough to push that car forward, setting off a domino effect. Car 1 hit Car 2 hit Car 3, and eventually one of those vehicles carried the woman now suing Ysabel. Initial reports describe scattered debris, flashing hazard lights, and a traffic jam stretching for miles. First responders arrived quickly. This portion of I-15 is patrolled heavily because of its accident history. No fatalities were reported, but multiple passengers complained of neck and back pain, and several sought medical attention on site. Officers issued Ysabel a citation for following too closely, a standard ticket in Utah for rear-end collisions. At the time, the citation seemed routine, a painful but manageable consequence of a highway mishap. No one imagined it would spark a lawsuit nearly 2 years later. But here's where the story deepens. Utah law requires drivers to maintain enough space to stop safely, and rear-ending someone creates a presumption of fault. Even in heavy traffic, the law expects you to anticipate sudden stops. Ysabel accepted the ticket but later explained, through her attorney, that traffic conditions left almost no room to react. Eyewitness statements support that traffic was erratic, but in Utah's comparative negligence system, the presumption still weighs heavily. For Ysabel, life went on. She was a college student juggling classes, part-time work, and the unique challenge of having grown up on national television. She didn't speak publicly about the incident, perhaps hoping it was behind her. The plaintiff, meanwhile, began a long recovery. According to the civil complaint, she claims persistent pain and injury severe enough to interfere with daily life. She alleges some effects may be permanent, though her filing does not list exact diagnoses. Under Utah's statute of limitations for personal injury, a plaintiff has 4 years to sue. She filed just under the 2-year mark, well within that window. Why wait almost 2 years? Legal experts say it's common for attorneys to build a strong case, collecting medical records, consulting with specialists, and evaluating long-term costs, before taking formal action. By August 2025, those preparations culminated in a detailed lawsuit naming Ysabel as the primary defendant. As we'll explore in the next section, that filing kicked off a high-stakes legal process involving discovery deadlines, insurance questions, and a headline-grabbing settlement demand. But in this first act, it's crucial to understand that what looked like a momentary traffic mishap, a few feet of braking distance lost, has now evolved into a case that could cost a young woman hundreds of thousands of dollars and months, even years, of courtroom stress. Coming up next, we'll break down the lawsuit itself, the plaintiff's exact allegations, the $225,000 settlement proposal, and how Ysabel's response sets the stage for a tense legal showdown. When the official paperwork finally arrived at Utah's 3rd District Court, the stakes of a once ordinary traffic ticket became crystal clear. The plaintiff, whose identity remains sealed in most public filings for privacy, alleges that Ysabel Brown is legally responsible for a chain reaction crash that caused significant, possibly permanent, injuries. The civil complaint paints a vivid picture. Ysabel was allegedly following too closely, violating Utah traffic law. She allegedly failed to keep a proper lookout and to maintain a safe braking distance. By rear-ending the car in front of her, she allegedly triggered a domino effect. Vehicle 1 hits Vehicle 2, Vehicle 2 slams into Vehicle 3, and so on, ending with the plaintiff suffering injuries. The plaintiff's attorney uses key language, words like negligence, carelessness, and proximate cause, that aim to lock in Ysabel as the primary catalyst for every subsequent collision. Utah's legal system assumes that the car at the rear bears responsibility unless it can prove otherwise, so that wording matters. Ysabel did admit to the initial contact. She acknowledged rear-ending the car directly in front of her. But she denied that her actions directly injured the plaintiff or that she alone caused the multi-vehicle chaos. Through her legal team, she argued she lacks sufficient information to confirm whether the plaintiff's medical issues stem entirely from that moment on the freeway. This is a standard but important defensive move. It keeps the door open to comparative fault, the Utah doctrine that divides responsibility among all parties involved. If Ysabel can demonstrate that other drivers braked suddenly or contributed to the severity of the collision, a court could split the percentage of liability and reduce any damages she owes. Then came the twist. On August 20, 2025, the plaintiff filed an offer of judgment, a legal mechanism that functions like a strategic chess move. In simple terms, it's a public settlement proposal stating, pay this specific amount now and end the case. If you refuse and we go to trial, and you lose, you may have to pay even more, including our post-offer legal fees. The figure attached to this offer? $225,000. That's not a random number. It reflects what the plaintiff's side believes covers past and future medical expenses, alleged lost wages, pain and suffering damages, attorney's fees and court costs, interest and any other financial penalties allowed under Utah law. To many observers, $225,000 is eye-catching for a chain reaction accident with no reported fatalities. It signals the plaintiff believes her injuries are serious and long-lasting, perhaps involving ongoing treatment or therapy. The 14-day clock. Under Utah civil procedure, once an offer of judgment is filed, the defendant has 14 days to respond. If Ysabel accepts, the court enters a judgment for that amount, and the matter ends, no trial, no additional discovery. If she rejects and the final trial verdict equals or exceeds that $225,000, Ysabel could be liable not only for the verdict but also for all legal costs accrued after the offer. It's designed to pressure defendants into settlement when the plaintiff feels confident about the strength of their case. As of September 11, 2025, public records show no acceptance of the offer. That silence speaks volumes. Either Ysabel's legal team believes they can negotiate a lower figure, or they're prepared to challenge the plaintiff's claims in court. One puzzling element is the absence of insurance companies listed as parties. Typically, auto accident suits name insurers or at least signal their involvement. It's unclear whether Ysabel's personal auto insurer is quietly defending the case behind the scenes or whether coverage disputes exist. If an insurer ultimately steps in, it can negotiate a settlement or absorb part of the payout. If not, Ysabel, still a young college student, could face a massive financial burden if the judgment goes against her. To understand why this matters, we need to peek inside Utah's comparative fault system. Here's how it works. Percentage of fault: a judge or jury assigns a percentage of responsibility to each driver. 51% rule: if Ysabel is 51% or more at fault, she pays damages minus any portion attributed to others. Shared liability: if other drivers braked recklessly or contributed to the crash, their percentages reduce Ysabel's financial exposure. This system is why Ysabel's attorneys are scrutinizing every police report, dashcam video, and eyewitness account. Even a 20% shift of fault to another driver could mean tens of thousands of dollars saved. For context, consider a similar case involving Ysabel's brother Paydon Brown, who once rear-ended a vehicle in Nevada. That incident, far less complex, with no multi-car chain, ended in a $35,000 settlement. The plaintiff's $225,000 figure here suggests far greater alleged injuries, possibly hospitalization or long-term treatment. Legal analysts note that serious whiplash, spinal issues, or head trauma can push settlements into the six-figure range, especially if surgery or ongoing physical therapy is required. So far, neither Ysabel nor the wider Brown family has commented publicly. Fans speculate whether her parents, Christine and Kody, longtime reality TV personalities, might help with legal costs if the case escalates. Some Sister Wives followers express sympathy, seeing Ysabel as a young adult unfairly burdened by an unfortunate accident. Others argue that road safety laws exist for a reason and that tailgating is a clear, preventable hazard. Online forums and social media have lit up with debates. Should she settle quickly to avoid spiraling legal fees? Or hold out, banking on shared fault to reduce damages? How might this case affect the Brown family's public image? What's next on the court calendar? The lawsuit is now on a detailed schedule. Initial disclosures from both sides are due by September 16, 2025. Fact discovery, where each side exchanges evidence, closes on April 14, 2026. Expert discovery and mediation deadlines fall on November 10, 2026. If no settlement occurs, the case will be trial-ready by late 2026. That timeline means this drama could stretch for more than a year and a half before any verdict is reached. So here we are, a young woman facing a six-figure settlement demand, a plaintiff confident enough to set the bar high, and a legal system designed to assign blame dollar by dollar. Will Ysabel cut her losses and settle, or will she and her attorneys gamble on a trial where the financial stakes could soar even higher? In Part 3, we'll pull back the curtain on the legal mechanics, how Utah's insurance rules, comparative negligence, and discovery process might shape every move from here. Now that we know the basic allegations and the eye-popping $225,000 settlement offer, let's look at the machinery that will decide whether Ysabel Brown ultimately pays a penny, or a small fortune. A civil lawsuit like this is essentially a structured conversation between two parties that starts the moment the complaint is filed. Each step is designed to surface facts, test evidence, and, in many cases, encourage settlement before a trial ever begins. Each side must reveal basic information, known witnesses, copies of police or medical records, and a list of any experts they might call. Ysabel must provide hers by September 16, 2025, and the plaintiff has already provided hers. This is the evidence-gathering marathon. Lawyers depose witnesses under oath, request documents, and subpoena medical or accident reports. Discovery can last months. Here it's scheduled to run until April 14, 2026. Accident reconstruction specialists, medical professionals, and insurance actuaries may all weigh in. Their testimony can be decisive in determining the percentage of fault. Deadline, November 10, 2026. Think of this as a formal sit-down with a mediator or arbitrator who tries to guide both sides to a compromise. Courts strongly encourage ADR to save time and money. If there's no settlement, the case is trial-ready, also targeted for November 10, 2026. Utah's comparative fault rule, why every percentage matters. Utah follows what's called a modified comparative negligence system, sometimes nicknamed the 51% rule. Here's how it plays out. If Ysabel is found 51% or more responsible for the crash, she can be held liable for 100% of the plaintiff's damages, minus any payments from the plaintiff's own insurer. If her fault is 50% or less, her financial responsibility is reduced proportionally. Example: if damages total $200,000 and Ysabel is 40% at fault, she pays $80,000. That's why her legal team is scouring every dashcam recording, police photograph, and witness statement. A small shift in fault percentage could cut her exposure dramatically. One of the biggest unanswered questions is insurance. Typically, a driver's auto liability policy provides a defense attorney and pays damages up to the policy limit. But several scenarios might explain why no insurer is listed as a defendant. Ysabel may have minimal coverage, and the plaintiff aims to secure a judgment first before negotiating with the insurer. The insurance company might be defending Ysabel quietly, choosing not to appear in public filings until a settlement is near. Or there could be a coverage dispute, for instance, if the insurer claims a policy lapse or delayed notification. If insurance is in place and limits are adequate, the insurer might eventually write a check for some or all of the settlement. If not, Ysabel could face personal financial exposure, an intimidating prospect for a college student. Keep pressure high with the $225,000 offer of judgment. Highlight Ysabel's traffic citation as evidence of negligence. Present strong medical documentation to show long-term injury. Argue that other drivers' sudden stops or unsafe actions contributed to the chain reaction. Challenge the severity or cause of the plaintiff's injuries, perhaps suggesting pre-existing conditions. Emphasize any discrepancies in medical treatment timelines or costs. These strategies will unfold during discovery. Every deposition, medical record, and accident scene photograph could shift leverage toward settlement or trial. The plaintiff's August 20th offer wasn't just a courtesy, it's a legal trap with teeth. If Ysabel declines and the jury later awards the plaintiff even $1 more than $225,000, Ysabel must also pay all post-offer attorney's fees and court costs. That means the longer she fights, the bigger the potential bill, giving her a powerful incentive to settle early if the evidence looks damning. Utah's I-15 corridor is infamous for multi-car collisions. State records show dozens of chain reaction crashes every year, often triggered by sudden congestion or high-speed lane changes. Some accidents require helicopter evacuations and can cause catastrophic injuries, even at moderate speeds. This backdrop helps explain why a jury might be sympathetic to a plaintiff claiming severe harm, and why her lawyers feel confident seeking a six-figure payout. While the lawsuit is a tangle of legal jargon, at its core are two people whose lives changed in a blink. A plaintiff coping with ongoing pain and the fear of medical bills. A young woman, Ysabel, trying to build an independent future while facing a financial cloud that could shadow her for years. Jurors often respond to those human stories as much as to hard evidence. That reality will influence every negotiation. Music rises, then softens. So the stage is set, a legal marathon with strict deadlines, a high-stakes settlement offer, and an insurance question mark big enough to swallow a young person's financial future. But lawsuits are rarely just about paperwork. In Part 4, we'll explore the broader family and public reaction, how this case intersects with the Brown family's unique history, and what it might mean for Ysabel's personal and professional life long after the courtroom lights go dark. As the legal machinery grinds forward, the lawsuit's ripple effects stretch far beyond the courthouse. For Ysabel Brown, the youngest daughter of Kody and Christine Brown, the experience is more than a line in a docket. It is a public test of maturity, responsibility, and resilience. Friends say she had only recently embraced adult independence when the accident occurred, balancing college coursework with part-time jobs and the usual milestones of early adulthood. Now every deadline, from discovery to trial readiness, represents a hurdle that could reshape her financial and emotional landscape. The broader Brown family cannot avoid the glare either. Sister Wives viewers have watched this plural family navigate divorces, relocations, and public scrutiny for over a decade. Christine, who left Kody in a high-profile separation, has been outspoken about protecting her children's privacy, Yet fans still speculate how she feels seeing her daughter's name attached to a high-stakes civil action. Kody, meanwhile, has historically clashed with older children over boundaries and responsibility. Observers wonder whether the parents, though long separated, are quietly cooperating behind the scenes to provide moral or even financial support. No one from the family has issued a detailed statement, and their silence has only fueled curiosity. Online forums and social media groups dedicated to the show have lit up with commentary since news of the $225,000 offer broke. Some fans express sympathy for the injured driver while urging accountability, pointing out that Ysabel was cited for following too closely and emphasizing that traffic safety is everyone's responsibility. Others rally around Ysabel, arguing that a chain reaction crash can happen to anyone and that insurance companies often push plaintiffs to exaggerate injuries to maximize payouts. In Facebook groups, comments range from practical advice about negotiating with insurers to emotional appeals. "She's only 20. Don't ruin her life over an accident," wrote one longtime viewer. Hashtags like #JusticeButFair and #SupportIsabel occasionally trend when new court filings surface, underscoring how deeply reality TV audiences can invest in real-world drama. The lawsuit also sparks conversations about the pressures of growing up in the public eye. Ysabel never chose fame, she was a child when the cameras first rolled. Yet the notoriety of the Brown name means every motion filed becomes tabloid fodder. Legal experts note that public scrutiny can influence settlement talks, since both sides understand that each new development might become a headline. A jury drawn from local residents may walk into court already familiar with the family saga, an unpredictable variable for both